Good day. My name is Don Green, and I'm an attorney in Nevada and California. Many of you may know me from other shows on the American Guns and Glory Network, and probably from most, if not all, of the gun shows in Nevada prior to the pandemic and most of the gun shows after the pandemic. We're here today to clarify a few points on probably what is the most significant decision of the U.S. Supreme Court in recent years, only to be outdone by the abortion decision about 3 weeks ago. The case I'm talking about is the New York Rifle Association versus Bruen. This is a case which went to the U.S. Supreme Court several years ago and has worked its way up through the system. And the basic point in this case was whether New York's law on how you can have a weapon, the requirements to get a weapon, whether that was violative of the Second Amendment. That's what the issue was, which originally went to the U.S. Supreme Court. But what happened at the case? May I have the first slide, please? What does the U.S. Supreme Court's decision in June of 2022 in New York Rifle Association versus Bruen, what does it mean on the average guy on the street? Next slide, please. We have a decision by the U.S. Supreme Court authored by Justice Thomas. This is a solid decision, very well crafted and very well presented. There have been a lot of criticisms of this decision, but what does this decision really mean to you? And I'm going to highlight something here. This is from page 62, and we'll go over this in a little while. On page 62, Justice Thomas said, and I quote, "The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules such as the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise after demonstrating to government officials some special need." That is, you had to show special need in California, you had to show special need in other states, and you had to show special need in New York. I'm continuing. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. Here's the ruling. And this is not a Second Amendment case. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. We therefore reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. Now notice, in this decision, the final paragraph tells us, and at the last gun show we had back at the end of June, when people were asking about this new Second Amendment decision, I corrected them. And they looked at the poster we had at the gun show, which verbatim quoted this last paragraph. It violates the 14th Amendment. Well, how is that? The 14th Amendment talks about substantive due process, and we have procedural due process. And that's what happened in this case. And this decision reinforced McDonald, which applied for the first time in almost 200 years, applied the Second Amendment to the states. Most people were talking about the Second Amendment for years, but didn't realize that it didn't apply to the states until the McDonald decision back around 2012, give or take a year. And the New York Rifle Association case reinforces an individual's right to keep and bear arms under the Second Amendment. So how did it turn into the 14th Amendment? because I think that this was a collaboration of members of the Supreme Court in order to get a consensus, a very solid consensus of 6 justices against 3. So this decision is solid law. There's no, well, it's only a plurality opinion. It is a solid opinion. We have to know what's the difference. What's a plurality? That would be like 4 people join here, 2 join here, another joins here. It happens all the time in U.S. Supreme Court cases. And for our average Joe on the street, what's important to him is not what amendment, but whether it's a right which you now have. May we have the next slide, please? In this decision, Justice Alito pointed out a very important point. And Justice Alito says on page 2 of his concurring opinion, our holding decides nothing about who may lawfully possess a firearm or the requirements that must be met to buy a gun, nor does it decide anything about the kinds of weapons that people may possess, nor have we disturbed anything what we said in Heller or McDonald versus Chicago about restrictions that may be imposed on the possession or carrying of guns. So Justice Alito pointed out what was not decided. So states have legitimate reasons to prevent certain people from getting firearms. Felons, people who are accused of battery domestic violence or have been convicted of battery domestic violence, people who are mentally deficient, people who have been dishonorably discharged from the military, people who are under indictment or information, people who are addicted to drugs. And remember, under federal law now, both the FBI and the ATF consider marijuana is still a Class 3 drug in federal law. So the possession or use of that drug is illegal under federal law. So you can't go to the marijuana store and get marijuana. You cannot have a medical marijuana card. These restrictions are not disturbed by the New York Rifle Association case, according to the very language of the case and Justice Alito's concurrence. And next, the types of weapons. Nothing in this decision disturbs the fact that there can be certain types of weapons and certain legitimate government restrictions. But you can't test somebody. You can't tell somebody you've got to have these requirements and show a special need, like they did in California in the Peralta case, which the U.S. Supreme Court refused to decide in around 2016. And that's the law of the Ninth Circuit. It might not apply in other circuits. And that was the original case that went to the Ninth Circuit from San Diego, in which Mr. Peralta was trying to get a concealed weapon permit, but he was denied because he couldn't prove special need under California law. That Peralta decision may be subject to question, or perhaps if someone comes up with the proper issue and the proper facts, it could possibly be raised if he or she is convicted, or if it's a civil issue, to go to the Ninth Circuit. May we have the next slide, please? So, to reiterate, what does New York Rifle and Pistol Association mean? And you might want to get a piece of paper and a pencil or screenshot this graphic. 1. The Second Amendment and 14th Amendments protect an individual's right to carry a handgun for self-defense out of the home. Now, that doesn't mean we are granting the right for concealed weapon permit or open carry. You still have legitimate restrictions by states. Number 2, we hold that the Second Amendment's plain text covers an individual's conduct. The Constitution presumptively protects that conduct. And write this down. That's on page 8 and page 15 of the decision. Here's what the government or the states must do. The government must affirmatively prove that its firearm regulation is part of the historical traditions that limits the outer bounds of the right to keep and bear arms. No one's going to question that felons should not have firearms. No one's going to question that people who are mentally ill or deficient should not have firearms. Almost everyone agrees that if you have a dishonorable discharge from the military, or you're not legal in the United States, or you're addicted to drugs, or you've been convicted of battery domestic violence, which has been upheld since 1995 when the Lautenberg Amendment was passed by Congress. So these are the outer bounds of these limits. 4, the constitutional right to keep and bear arms in public is not a second-class right, subject to an entirely set different body of rules other than the Bill of Rights guarantees. We see that all the time. No one's going to question a First Amendment case, but you can't yell fire in a crowded theater. That's been the law for over 120 years in the U.S. Supreme Court. And so there are restrictions on speech. Is nude dancing protected speech? Yes. Is silence protected speech? Yes. You can have civil disobedience where the silence is deafening, where you don't say anything. That is protected speech. But these were always treated different. These cases were always treating the Second Amendment differently. They were trying to put more restrictions on them. They were trying to go back, as Nancy Pelosi and AOC want, to go back to carrying muskets, like at the time of when the Founding Fathers enacted the Second Amendment. And people don't realize that the Second Amendment preamble talks about restrictions on the government. It does not talk about the rights which are going to be enumerated, but these are restrictions on the government action. And you'll notice that the restrictions are every single amendment up to the 10th Amendment are all restrictions on the federal government. And people have forgotten that. And people have forgotten that when the U.S. Constitution, now remember, the U.S. Constitution was 16 years after the signing of the Declaration of Independence, and the amendments didn't come out until several years later. And the amendment which had the most drafts of the drafting committees there in the constitutional conventions after the Constitution was signed, it had 7 different variations, more than any other amendment in the first 10 amendments to the Constitution. 5, here's the holding again in New York Rifle Association. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising the right to bear arms. That's page 63. I would cut that out and put it in my wallet. And then Justice Alito's concurrence is very important. Our holding decides nothing about who can lawfully possess a firearm or the requirements that must be met. Now, this has generated some lawsuits. And the first one was a decision is less than 36 hours from the time of this broadcast, which is on Sunday, July 24th, 2022. At about 3 o'clock p.m. Mountain Standard Time in Colorado, a federal judge in the case Rocky Mountain Gun Owners versus the town of Superior, Colorado, issued a temporary restraining order which prevents the town of Superior, Colorado from enforcing its assault weapon ban. So the decision is good for 14 days until there's a hearing on the merits. Now, for those of you who may not be familiar with temporary restraining orders, if you have a temporary restraining order, then you'll get a preliminary injunction. And a preliminary injunction under the Federal Rules of Criminal Procedure, the court can consolidate the case for trial. So we may have a trial on this case in 12 days. And this is the first case of which I'm aware. And we have a network of attorneys across the United States we work in conjunction with each other, sending each other court cases and information on legislation in our particular states. So a buddy of mine emailed me this decision from Colorado. And in this case, it refers to, in great detail, it refers to the New York Rifle Association case. And let me read you from the decision. The motion for restraining order is granted, and the municipal code of the town of Superior and the defendants are restrained from enforcing that position of the assault weapon ban. And they're also restrained from the particular section of which they're interpreting their own rules. They didn't require a bond, and the motion for other parts of the restraining order were denied, but it's not relevant for us. But in this case, the judge say that on showing of good cause, they may apply to the court to try to dissolve this temporary restraining order. But I think they're going to wait the 12 or 14 days and then file their papers in between saying that it should never have been granted. So I hope that clears it up. for the listening audience. And if you have any specific questions on the New York Rifle Association case, I'm only licensed in Nevada and California, so if you call from another state, I can tell you what the decision means, but I can't tell you how that applies in your particular jurisdiction. Like in Texas, it's going to be a little bit different. So if you have any questions, please call me at 702-409-8239. And I hope this little mini program has been informative and clears the air as to what New York Rifle Association really means. Thank you for watching.